Before we start, I don't know if you heard earlier, I would remind of telling if you wish to reserve time, please let me know. I'm your timekeeper.
Oh, you are? Thank you. To please the court, I'd like to have 15 minutes and reserve 5 minutes for rebuttal.
Okay. Thank you, counsel.
Yes, sir. Well, first let me say it's a pleasure appearing before 3 former trial judges. I have long since stopped the practice of arguing my own appeals. Heather Barnes just gave birth to her first son, so she's unavailable today, and I'm happy to say, for a good reason, I will be taking the appeal on. And as I said, I think part of the value of any experience is listening. I've learned more by listening than I've ever had learned by talking. I've lost 7 cases in my career, and this case has a distinction of being the case I've lost twice. If I get my wish today, then I have a chance of losing it for the 3rd time, but I want to lose the case for the right reason. And you asked a good question earlier, what's the standard of review? And I studied this pretty hard before I got up here, and I think Judge Crenshaw set forth the standard of review quite well in the Oliski case that we set out. And that standard of review, while we generally review the trial judge's rulings on the admissibility of evidence for an abuse of discretion, a court's discretion is limited by the evidence code and applicable case law. And the case that I cited, that Thigpen case, I think it's out of the 4th, talks about how the abuse, the standard lessens as you get to something that you can appreciate. That is the rule of admissibility. And what bothered me most about this, since I did try it, was Judge Silver's insistence that, well, if the waiting room had been full, then that may have made a difference in his ruling on the admissibility. What happened here was really, I haven't been ambushed that often, although I will tell you this defense lawyer in this case, who was admonished, at least in my view, rightly so, took the consequences of the misconduct in the first trial. He was very clever in the second trial, very, very clever. For example, one of the things he did was, and I didn't know why he did it, one of the things he did early was he put the caption of the case with the defendant doctor who was dismissed without any money, anything else. I just felt that he was an agent of this professional association. He put that up for the world to see, and I didn't notice it was up until the jury kept looking at it, and he's got a former defendant in the caption. There was nothing to the caption. That was it, just a cover sheet of a deposition. But the purpose was served because, of course, in final argument, what he was able to argue was this was a case against this young doctor whose wife was there every day and periodically did cry. I'm sure she emoted for good reason, but we couldn't exclude her. And she was on the first row, and she cried every time that things didn't go well for the defendant doctor. I've got that, but he wasn't a defendant doctor. This was a defendant corporation. What happened early on in the case, and this is critical, what happened early on in the case was we called Dr. Nadal, who owned Nadal Pediatrics. We called him for the express purpose of showing that these doctors that he employed at very low wages, $75,000 for a board-certified doctor, were incentivized to see more patients. They were generating their revenue based upon the amount of patients, the amount of patient flow, their proficiency in coding, and that was the culture. This young doctor had been there 6.5 years. He'd never been employed anywhere else. So what I told the jury, and I laid it out quite well, I think, the evidence is going to show that Dr. Kinerick was an employee for 6.5 years. He never owned any ownership interest. He was a pure employee. His compensation was based largely on productivity, and that patient revenue was important. And I told the jury, we're going to tie that in as to why. I went on, I said, the timing exam in this case is going to be critical. It was a medical mill. It was a pediatric clinic that was nothing more than a medical mill. They didn't do proper intake. This kid presented with shortness of breath. He was shuffled into a room. 30 seconds after the doctor got there, he announced to the parents that he had the flu. 41 hours later, this kid died of strep, invasive strep. So the point was, there wasn't a thorough exam. Well, guess what? I brought the parents in to testify that the exam was less than 3 to 5 minutes. They couldn't estimate how. And as I said, he's a very clever defense lawyer. Mr. Josepher kept on and on and on about how it was a thorough exam, how it took a great deal of time, 15, 20 minutes, maybe longer.
Mr. Year,
Yes.
let me ask you this, because
Sure.
First of all, this is a tragic case.
Yes.
I mean, this is really a tragic case when you hear about a baby, dying.
Yes, Your Honor.
Pushing that aside, we look at what is the standard of care.
Yes,
And
Your
if you look at the standard of care, you could have a doctor take 5 minutes and do everything that he needs to do, and it would be within the standard of care. And you can also have a doctor that will take an hour with you, do the same thing, and will be well within the standard
Yes,
of care.
sure.
So the time itself, I guess the issue becomes, what did this physician do in terms of that, examination, and was that within the standard of care? Because when we look at it, the question becomes, when admissibility, what is relevant testimony?
Totally understand.
So let's discuss all of that.
Let me tie that up. First of all, the thoroughness of the examination was very important. In other words, you could take a world's amount of time and still miss things.
True.
But in a failure to diagnose case, which by the way is what Judge Crenshaw wrote in her opinion with regard to the standard of review, this had to do with ordering tests, things such as that. Additional, our experts were all in accord with the fact that things weren't done that should have been done. That goes to the brevity. What bothered me most was when Judge Silver said, well, the waiting room wasn't full. If the waiting room had been full, he might have been in a hurry and we would see haste makes waste, mistakes can be made. Okay, the problem is their testimony was that the clinic closed at noon, but they were keeping the clinic open for the purpose of seeing this 22-month-old infant. It was 11 o'clock when the child presented. What Judge Silver said was right, but for the wrong reason. There was no one in the waiting room, meaning once he got the office visit charge, that child was the only thing separating him and closing the office, because they were going to close as soon as the child left. The point being, with a hasty examination and all the things weren't done, we spent hours on the one-page examination, and all of the things that weren't checked, all of the things that weren't ordered, no x-rays, no blood tests.
Well, and let's talk about that, Mr. Yard,
Sure.
because a lot of now, the average juror, they use common sense, and I think most of them have young children. And I know your expert, when he testified, okay, what did the baby present himself with? What was the fever? 102.7. Then you did a great job asking him, okay, there's that fever. A lot of parents have been told, don't even bring the child in unless it's 103, 104. So he testified that fever was high enough that he was recommending, or he maybe said it was a deviation from the standard of care in failing to take an x-ray of a baby. How would that, don't you think the jury may say, wait a minute, that makes no sense?
Excellent question. And the reason that it's so important that we give that issue to the jury was to show he didn't do all he should have done. Because in addition to that, and I'm so glad you read the record, one of the things about you is I know. One of the things is, as trial judges, you prepare. I got to tell you how refreshing that is. It's unbelievable, as opposed to just walking in and saying, what is this case about? Yeah. In addition to the elevated fever, Judge Kazam, the child had shortness of breath, which was reported on the outside front office person, but the doctor said never was mentioned to him. The point being that the brevity of the exam, he was in a hurry. Now, whether it was said and he just didn't hear it, I don't know. Whether there was, but the whole crux of the case was, let the jury determine what happened in the examining room. Why is it important to show that this person had a culture of practice where patients were moved through quickly? Was because the jury could certainly determine that, well, you go to Dr. Smith, he's got good bedside manner, he spends a lot of time with you, he asks questions. Taking a history is critical of an infant from the parents, because the infant can't give the history. So when the parents say, he didn't give us a chance to talk, we tried to tell him the baby was short, but he seemed he was in a hurry. Was what? That whole confluence of events coincides with how this doctor was practicing. And what I'm saying is, the judge thought it was very important. Those were his words, not mine. The judge also let that testimony in to Nadal Pediatrics, how they incentivize pay. What was not tied up? You have to appreciate. I could never tie up, no matter what I said in opening, what I said in voir dire. When is the last witness Mr. Joseph got up and emphasized how long and how thorough this exam was, and this took how many minutes, and this took how many minutes, and then over and over. In cross, when I got up to say, well, isn't it true, and you read the question, I would not only had my legs cut out from under me, you understand that, forget that. I couldn't bring that up in summation, and I never tied in the acts of the agent or omissions of the agent, incentive of the agent, to the principal and the sole defendant. He was never the defendant in this case. It was always the corporation. So the point was, I couldn't get up and say, folks, they set this in motion for this thing to fail, where patients wouldn't get due care, where they wouldn't get appropriate time, where testing wouldn't be done. I couldn't say any of that. And Judge Silver confirmed, contrary to what, and she's a very good lawyer, but contrary to what they said in their briefs, that didn't happen. I didn't argue that in closing. And I clarified with Judge Silver. He said, I would have never allowed that. I ruled, and I don't have to hear a judge twice. I try to comply with what the judge says the first time. That's what's important. And what I'm trying to say, and I want to be very clear with you, at the end of the case, the defendant that should have had active negligence by setting in motion an incentivized system of pay whereby doctors were encouraged not to take their due time, not to operate in an appropriate, comprehensive fashion, that defendant had no liability. I could not argue any liability on that defendant's part. The only thing I could argue was that the doctor, something happened in the room, we're not sure what. Our expert wasn't in the room. The only thing that would be salient would be, and they talked about inference upon inference, and you know the difference between civil and criminal. Some of you all been on the criminal bench, and you know that the standard is much less stringent, and I could have gotten in evidence about the fact that, hey, this was the only person there. You flip it on his back, okay, he was in a hurry to get out of there because once he got the office charge, why would he want to stay there any length of time? And this stuff about, well, gee, he would have made more money if he ordered additional tests, that's rubbish. We know that, first of all, that's illegal. If he would have sent the kid out for x-rays, it wouldn't have been there that he got the x-rays. If he had other medical tests, blood work, it wouldn't have been there that got the blood work. He would have gotten no additional money. I'm not saying that he was malicious. I'm not saying there's bad intent. But that's not for you to decide anyway. That's for a jury to decide. It's not for a trial lawyer to be cut off by a trial judge because a trial judge opines as a seventh juror, more or less, oh, well, no, I can see where it would be admissible. This was admissibility we're talking about. Admissibility of evidence at the trial level. And the plaintiff should be entitled to talk to the jury about, well, one of the things you should look at is how they set this system up and how it would be subject to making mistakes because quick exams were the norm. And by the way, recall that I not only set this up in voir dire in an opening, you do understand there wasn't an objection raised when I put that video in of Dr. Nadal, the owner of Nadal Pediatrics, nothing. So the first time I got drilled was when this doctor was on the witness stand and I was on cross. At that moment, the judge not only reversed course, he instructed the jury that I had done something wrong. By the way, in their brief, they say that I wanted to bring in his income. That is not accurate. What I wanted to bring in was the nature of his income, if that makes sense. Not his income. I understand that. Big guy versus little guy, six-figure doctor, moneymaker versus this little poor patient. No, that's not me. You know that. You know that. What I wanted to bring in was the incentivization of a doctor, putting a doctor in that position where to make money, they had to move patients. And you may not agree with it, Judge Kazan. You may say, well, doctors going, but, and understanding some people may be mothers and fathers, that is not for a judge to decide, with all respect. It is not appropriate. Well, if he'd been rushing to go to a doctor's appointment, I would think that would be admissible. It wouldn't be any more admissible than this would be. It either is or it isn't. And there's no gray area here. And what I'm suggesting to you is it was important, it was critical to our case, and what happened in the final argument by this clever lawyer could not have been a more coup de grace. He got up and he said, I was muted. He got up and he said, and you've got this doctor's actions to judge. This doctor is on trial. And the jury verdict will say, was Dr. Konerik negligent? Was Nadal Pediatrics negligent when that lawyer knew absolutely there was no Dr. Kanarek on the verdict form? Yet, remember what I told you happened earlier. Dr. Kanarek was placed in broad display up there as a defendant in the case. And then I got it. Then I got it, but I couldn't do anything about it. You can't. If you have a way to reverse a trial judge that does that, I would strongly urge you to do it, because it wasn't just unfair. Was it critical? It was critical. Could we have lost the case? We could have lost the case. Is it more likely than not we'd have won the case with that? Yes, it is. Because what's happened in our society is doctors do spend too little time with our patients. What happens in our society is either too many tests are run unnecessarily, or not enough tests are done under the appropriate circumstances.
You're at the 15.
I have not used 15. Okay, I'll take 30 more. Can I take 30 more seconds, or do I have to sit down? Okay, I'll just take 30 seconds and wrap it. Thank you very much. You're a great timekeeper. All right. Let me see. Yeah, I don't want to underemphasize, and I will take 30 seconds of my time, but I want to please emphasize enough that the link was never made. What I told the jury, you know, the worst thing you can do as a trial lawyer is misrepresent yourself to a jury. We're going to show how this doctor had incentivized pay, that movement of patients was important. I never showed that. Despite what they say, I never argued that to the jury. Believe me, I know how to argue cases to the jury. And believe me, I don't look forward to trying a case for the third time. But these parents, as horrific as the loss was, I wouldn't have taken this appeal if I didn't believe they had been wronged. As horrific as the loss was, I didn't expect Judge Silver to give him any pity. What Judge Silver did was insert his judgment as to why that was probative or why it wasn't probative at the worst possible instance, the gatekeeper instance of whether something is admissible. And you've all been trial judges, and I doubt any of you would have ruled that it was inadmissible. That's just my view. But maybe you would have, and maybe I wouldn't be here. I'll spend the next 4 minutes trying to rebut what my colleague, who I respect, as I said, a great deal. None of my comments were directed toward the appellate lawyer. They were all directed toward trial counsel, and I stand by every one of them. Thank you.
Thank you.
May it please the court, Dinah Stein on behalf of Nadal Pediatrics. And this appeal boils down to a single evidentiary ruling, and that was the court preventing plaintiff's counsel from asking Dr. Kanarek what he earned in 2005. If you look to the objection and, in fact, the court's curative instruction, that's all that was kept out. And, of course, it's the defense's position that this was not only well within the court's broad discretion, but absolutely correct given the facts of this case. And first and foremost, the threshold issue that we raised in the brief is preservation. And we really don't know what Dr. Kanarek would have said. He could have said he made $75,000 that year. He could have said $500,000 or something in the middle. This was never proffered. He was never voir dire on the stand. So at this stage, both counsel and the court are left to speculate as to what this alleged testimony would have been in the first instance.
You know, Ms. Stein, because Mr. Yurt seemed concerned with the fact that at least his theory of the case was, here's his doctor, very quickly, in and out, in and out. So let's look at the trial testimony. Was he able to bring out that theory of the case through his case in chief?
Absolutely.
Okay, walk me through that, because I want to make sure Mr. Yurt will have an opportunity.
Absolutely. And when I say this, I'm going to put the threshold is that there was no direct claim against Nadal Pediatrics. This was purely vicarious. However, even given that, he put on the testimony of Dr. Nadal, who was questioned, I think it was through his deposition, but he was thoroughly questioned as to the compensation structure of Nadal Pediatrics. And he testified that there is incentive bases. They get the $75,000 base salary, but then can make more based on either number of patients, but not only that. He said it could be tests performed, and he said a very, very important aspect of that is billing and proper coding. So when, in fact, Dr. Nadal was point blank asked, so it depends on patient load, he said not really. Depends on a lot of factors. So that was absolutely brought out during trial, and that went before the jury. Now, the Other things that were brought out by plaintiff, which were permissible, were how much time Dr. Kanarek allegedly spent with the child. And something I want to just point out, it's very important in what Your Honor pointed out, and it's the first thing that Judge Silver honed in on when this came up to the bench conference. He said there's been no expert testimony that the time spent was below the standard of care. And that was absolutely correct, and I've carefully gone through Dr. Stallings' testimony. He never said that Dr. Kanarek should have spent more time with the child. He concentrated, as Your Honor pointed out, on whether the proper tests were performed and whether this disease, this horrible aggressive disease, could have been anticipated at this time. He never said that there was a default in the standard of care. When he talked about this being an in-and-out exam, he was asked whether Dr. Kanarek played with Sammy and hid quarters behind his ears to see if he'd laugh. And that it was in that context. He said, no, this was an in-and-out exam, but there was no testimony regarding this. And that's critical, and that was Judge Silver's first concern. The other relevance point being, in fact, there's several, that there was testimony that Dr. Nadal said that this was not based on patient load. It could be anything, so we have that problem tying these things together. Another very, very important point that Judge Silver, I keep wanting to make him a doctor, that Judge Silver was very concerned about and discussed very in depth during this bench conference was the predicate and the fact that there was no patient waiting at the time. He was very concerned with trying to make this inference that Dr. Kanarek would have been rushing when there was absolutely no incentive that day based on this patient load compensation theory to rush, because he probably would have made more money had he ordered more tests for Sammy, which Dr. Kanarek did say he could have done in the office. The x-rays would have had to have been outsourced, but he said, if a blood test would have been done in the office by the nurses, it wouldn't have held me up at all. I believe the pulse oximeter could have been done in the office. So again, we're taking an inference that really wasn't supported by the record. And again, this whole assembly line business model theory that the plaintiff has, again, it's important to just go back to the fact that there was no theory against Nadal Pediatrics of this assembly line. Now, it did come out. The court allowed it through Dr. Nadal. I don't know that it was even objected to. So he did get to present that. But this is not a situation where there was a negligent hiring and supervision or anything like that. This was pure vicarious as to what Dr. Kanarek did or did not do on this day. And finally, the court was also concerned about the 403 balancing. And I'd submit that when you start getting into salaries, when it's got de minimis probative value, you're in a dangerous area. The jury would have really had to stack inferences to get to what this salary meant. It very easily could have gone the other way, the wrong way on this. And that's problematic because even though Dr. Kanarek wasn't an actual defendant, he's sort of a de facto defendant because it's only his alleged negligence at issue. And to just show either that he was a highly paid doctor or perhaps that he was a low paid doctor and that the practice is underpaying its doctors. These are things that have nothing to do with whether he rendered a proper examination on the day he examined Sammy. And again, even if this evidence had come in, the jury would have had to stack a lot of inferences, such as it would have had to assuming he had a high salary, which again we don't know, that this was based on high patient load. It would have had to assume that if it's based on high patient load, this caused doctors at Nadal Pediatrics to rush. They would have had to infer that when they rushed, they didn't do the exam properly. So again, we're in an area that is far afield from the evidence and predicate.
Let me ask you this question. So if Mr. Yaird's expert would have testified that in his opinion, the time that was spent examining this child was below the standard of care, that would have been sufficient for all that testimony to come in regarding, the fact that, okay, hurry, let's go ahead and to use, it would be an incentivization for the doctor.
Right. I don't think that would have been enough under these facts. I think it's simply one factor, because even if he had said there wasn't enough time spent, and that's fine. We had testimony from the parents versus Dr. Kanarek as to how much time was spent, plus the medical records, but we still don't have testimony that this incentive structure is somehow negligent and causes people to do things quickly. I don't even know, you may need a human factors expert on something like this. The other problem being the basic predicate in this case is the fact that even if he had said that not enough time was spent, what does this have to do with what Dr. Kanarek earned that year? And we still have the fatal fact to the plaintiff that there was no one in the waiting room waiting. So again, even if you have this testimony, and even if you had more, you just don't have the predicate to make what Dr. Kanarek was earning that year relevant to whether or not this was a proper examination of Sammy. And just to look at the big picture of this, this was really a minor issue in the case, and the case very much concentrated on the examination of Sammy, as shown by the fact that their own expert never focused on rushing or any kind of compensation structure. The plaintiffs never called Dr. Kanarek himself to testify on the compensation structure. This was an attempt to bring it out on cross when it was not an issue on direct. And really the focus of this case was very much on standard of care and causation, whether or not this was a infection that could have even possibly been present 41 hours before the child had passed away from a very, very rapid infection. That was the focus of this case. And this one evidentiary ruling was not only well within the court's discretion, I believe was very proper given the rest of the evidence and the lack of predicate in this case. So I would submit that this jury's verdict and the judgment be affirmed. Thank you.
Very quickly, it's very hard to prove a negative, but our expert did say that the exam, for whatever, he did not know the reason, was shortcutted, that it wasn't thorough, that it wasn't comprehensive, that a basic fundamental exam would have picked up this child's malady. Whether it would have picked up the strep or a reason to order tests that revealed the strep is unimportant. But I was there, and let me tell you, the method of compensation was what I addressed, and I went while she was talking, and let me go through this. Let's talk about your contract. This is a doctor. Yes, sir. This is the question that caused the problems. Your base contract in 2005 was you got $75,000 plus an incentive based upon revenue brought in. Dr. Nadal was called as a video witness. He testified that patient flow, revenue generation, was critical to the incentive payment, and that some doctors did not get any incentive payments, meaning they would be paid a base pay of $75,000 if they didn't move patients. Okay, so that was the question. I didn't ask him what his income was. I wouldn't have asked him what his income was. I may have gone down that road a bit further, saying, so there's an incentive for you to move patients to the office quickly. Does that mean you wouldn't take as much time as needed? Oh, no, I would take all the time. That's a jury question. That is not... Okay, let me go on. I also wanted to say that during the final argument, and after I was hamstrung, counsel took full advantage of that by talking about, I never brought in why I had said that in opening, why that was alluded to, that this had nothing, just like the lawyer just said, that had nothing to do with the corporation when it had everything to do with the corporation. I think the corporation was at least as culpable as the young doctor, because they threw the die. I mean, you know, we talk, many of your cases, especially in premises liability, Judge Casanova, you've written on it before, on premises liability about a foreseeable zone of risk. I mean, it's a zone of risk when you put doctors in a position where they've got to choose their pay over doing a job. And it's not something, I suggest to you, You know, it's almost a difference between an hourly rate lawyer and a contingent fee lawyer. I mean, I like people with skin in the game because I happen to believe at 11 o'clock at night, they want to try a little bit harder than maybe somebody that's going to put their hourly time in. That doesn't always apply, but it's something that people should be able to consider. It's something that this jury should have been able to consider. And at the last moment, instructing a jury to disregard that, to make me look as if I represented something that had no basis, was a crippling blow to us, I can't tell you. And then for the defense lawyer to get up and take advantage of that, knowing I was muted, he got up and he asked the questions after this on redirect. Well, now, you didn't take any shortcuts. You took plenty of time because you weren't in a hurry. And he rubbed our face in it. And my point would be that if you teach someone to do a certain way, it's like teaching a young lawyer. If you teach them to do someone to do something a certain way, the chances are they're going to do it that way. My point would be that this employee had never had any experience any other place except in the Dahl Pediatrics. And if you'd seen the Dahl, because I played in my video, you would understand that his credibility was also an issue. He did not make a great appearance. His demeanor was not very good, and I would suggest the jury was really going to question his credibility. It looked like a money operator. It looked like a money machine. He didn't make a good appearance. That's why I played his video. But it wasn't a long examination. It was a video examination. I know I'm almost out of time, so I'll...
Go ahead.
I am out of time. Well, you see, great minds don't always think alike, but thank you so much for your courtesy. I appreciate it. Thank you.
Thank you both.
Thank you, Mr.